You're watching Capital Connection from the Illinois State Capitol.
Welcome back. In the past few weeks, the state has published a trove of data from the past 10 months on how no cash bail is working in the state. Joining us to help break down that new data is the director of the Office of Statewide Pretrial Services and former Cook County Judge, Cara Smith. Thank you so much for joining us.
My pleasure, Cole. Thanks for having me.
So we're 10 months into this process. We're 10 months into the new system. This data coming out now and being available so frankly quickly into this and early into this process, what does that mean for how the state's going to proceed to have this publicly available for everyone?
Well, the Supreme Court is tremendously committed to transparency, and the publishing of this data is our first step towards what will be, I think, ongoing expansion of the data that we are making publicly available. Never before has pretrial data for 75 counties been available like it is on our dashboard. It's searchable by county or by circuit, and hopefully interactive in ways that the public will find very interesting and useful, as again, we're all navigating this new world of the criminal justice system in Illinois.
Before we get into the numbers itself, I do want to ask just a couple caveats real quick. You mentioned 75 counties. Obviously, that's not all of them in Illinois. Some of them are some of the bigger counties. Why is that data not included in the Supreme Court's data set that's available?
So a couple answers to that question. The first is that the Office of Statewide Pretrial Services was established in September of 21 by the Supreme Court prior to the Pretrial Fairness Act taking effect. And we offered to act as the pretrial service agency for any county that wished us to, free of charge to the county and free of charge to the defendants. So we started out with 59 counties, and as time has gone on, additional counties have asked to be served by us. So we're now at 75. We have 6 counties that are in the wings waiting to be brought on board. So by early fall, we'll be at 81. And we're happy to serve any county that wishes to have us act as their pretrial services agency. In addition to that, there are 2 other projects that the AOIC is working on to have pretrial data from 102 counties. So that will be available later this fall as well.
And there's also data, there's like the Sangamon County, for instance, isn't included in this. Cook County isn't included in these initial statistics. But that data is available in other capacities for those counties, correct?
On the court's website, there are the dashboards available from Cook County, DuPage County, Kane County, McHenry County, and then the 75 counties that we serve. So really the majority of the state has some form of pretrial data available and more to come.
Got it. So getting into the data now, it's interesting to see the big broad numbers that were found when looking at statewide. I believe it's 61% of petitions to detain were granted by judges in the state. There were around 16,000, I think, cases totally seen over those 75 counties that we've been talking about. These numbers, and if I've messed one up, please correct me, but these numbers were, what story do they tell?
Great question. I always want to ask that about data. So I think the big picture story that this data tells is that despite all the concerns prior to the effective date of this new law, once the law became effective, everyone did their job and everyone is doing it well. Everyone is taking their role, whether it's judges, state's attorneys, defenders, taking their role in this new world very, very seriously. So we've done about 17,000 pretrial investigations since September 18th. What that means is those are defendants that were arrested and lodged in a county jail prior to their first appearance. So our staff interviews them, prepares reports, and provides those to the court and the parties. Of that 17,000, about 52% contained at least one offense that was detention eligible. And of that number, of those that were filed, 62% as of this morning of detention petitions were granted. So what does that 62% number tell us? It tells us that not all of them are granted, that judges are carefully evaluating whether the state has met its burden of proof in these cases. And things are going exceedingly well, I think. And I think everyone should be proud of the work that's being done in all counties across Illinois to navigate the big changes that occurred.
I'm interested in I guess the benchmarks for this, because with such a new system, something in this particular way that hasn't really been done before, especially to this scale, how do you determine what is a good data set? What is, how this is supposed to look when looking at this data?
Yeah, I'm not sure. I'm not sure there's a good answer to that, Cole, because it's all new, because we've never done it before. I should say that we are going to be building on and making more data available through our dashboard, including new arrests, defendants on pretrial who are arrested for new offenses. That's something that we have in the works right now. But I think that looking at, if you're pulling up a particular county, for instance, it's important to look at how many cases were there, how many contained a detention eligible offense, how did the state's attorney exercise their discretion, and then what were the outcomes? And looking at that entirely from the point of what was the defendant charged with to how did the court evaluate the petition that was before the judge. Those are all really important questions to be asking as you look at the data.
The other part of this whole conversation, especially as the new system has been implemented and in the months after, there's been this conversation about the weight of all of those hearings, the workload that comes with that, and is that something that is currently being tracked in this data? Is that something that could be there could be a deeper dive coming on that kind of those kinds of issues that are facing counties? I know there was a significant increase in the amount of pretrial process because of this system.
We are not necessarily tracking the time, but certainly there's more involved in preparing for first appearances. So the state's attorney is deciding whether they are going to seek to detain a defendant. Certainly our staff, our operation is, we function 24/7. So we have staff that are identifying newly arrested defendants across all of our counties all day, every day. So it is more work, but the question of someone's liberty is probably one of the most important decisions that are made in a case, other than the ultimate outcome. So the time that's being spent at the front end is time very well spent, and I think it's what is constitutionally required as well.
During the lead up to both the debates around the Safety Act itself and then the lead up to cash bail actually being eliminated, there was a lot of, for lack of a better word, guessing about how this was going to go. There was a lot of politicalization around this particular topic. And because it was a new system, there just wasn't exactly a example to point to of like, this is exactly how this is going to work. The lawmakers who were in charge of writing this legislation were very clear that this was going to be an ongoing process. There were going to be tweaks down the road. How important is this data set to making sure that those kinds of politicized conversations and that, frankly, fear-mongering that came with this system doesn't pop up when maybe when the law gets reopened?
But I think it's a great question. I think it's very, very helpful to be able to, what data does is it just sort of quiets both sides of the argument, right? I mean, the data is what it is. And while depending on who the viewer is, you might have different takeaways for it. I think it goes a long way towards revealing just how well implementation has gone. The Supreme Court devoted an enormous amount of resources through the AOIC to making sure there was ample training and education around all these big changes, so that once September 18th came, the sky did not in fact fall. Everyone, we got through September 18th and September 19th and September 20th. And here we are, 9+ months in, and the system is working exceptionally well, in my opinion.
To kind of go at that question from the other side, I guess now, I know when talking about collecting data, creating data sets, more data is always welcomed. 10 months in this first dump, is it too early to say, this is the story. This is how this this is how this is working now, this is how it's going to keep working, I guess. Is this the full picture?
Well, I think, that time will tell. I mean, our data is updated every evening at 6 p.m. I watch it every day, obviously, and the percentage of detention petitions that are granted hovers right around 62, 63, 64%. And that seems like a reasonable number to me. Obviously, every single individual that's standing before a judge is unique. His or her criminal history, their pretrial assessment score, their history of failing to appear. So without being able to get that granular, I think the data that we have made available and that AOIC and the court will continue to make available is going to go a long way towards illuminating just how well this is going across the state.
Got it. Well, Kara Smith, thank you so much for joining us today.
Oh, it was my pleasure. Thank you so much for having me.
We'll be right back.